Phillip Taylor speaking from Richmond Green Chambers. I'm reviewing an article which I wrote for the Barrister magazine. I'm the reviews editor of the Barrister magazine, and I produced an article on expert witness conference matters. It was in the Barrister magazine for Hilary Term of 2014, January to April 2014. A long time this time round, and this is actually the review. I'm just going to find it for you in the publication. It was very much part and parcel of what we were doing at the time. That's the actual review. You can see some photographs of there as well. It's a 4-page review of various people who were present, and what I thought I would do is just explain what I've written in the article so that people are aware of what happened in 2013 at the Expert Witness Institute conference. The Expert Witness Institute returned for its 13th year to the excellent facilities that are on offer at Church House Conference Centre, which is next to Westminster Abbey. And there were over 150 experts and members of the legal community who participated in a day full of legal updates, expert training, workshops and question and answer sessions. And the conference was chaired throughout by Amanda Stevens, who's a photograph of her in the journal, and she reviewed through the conference itself recent legislative changes, mainly the Jackson reforms and the LASPO bill, as it then was, to anticipate how the issues would shape the legal landscape, which inevitably will have some effect on the role of the experts for the future. And I believe it was of great practical benefit to the attendees I spoke to hear the range of the legislative changes which were actually being proposed or had actually taken place. And obviously there was, frankly, a certain amount of grumbling about various things, but we'll get on to that in a minute. There were interesting speakers, and I attended virtually the whole of the sessions where I could. There was a keynote speech from the Solicitor General at that time, Oliver Heald, Queen's Counsel, Member of Parliament, and an inaugural address from Sir Anthony Hooper, who's the new chair of the EWI. And other contributors were Michael Turner, Queen's Counsel, Simon Reevell, Dr. Heather Payne, District Judge Suzanne Byrne, always good value, William Featherby, Queen's Counsel, Dr. Harry Brunges, Mark Stobbs, also very good value and known to many, of course, Stephen Green, and Dr. Chris Pamplin, who was also interesting with his comments. The conference was really about 3 major issues of the day: the government's defence of its austerity policies, the serious effect that the policies are having within both the world of the expert witness and the world of the lawyer, and the future development of EWI under the new leadership of Sir Anthony Hooper, who's now succeeded James Badenoch QC. And I actually was able to meet all of these gentlemen and have an interesting discussion and some feedback, which is part of what's in the article. The conference began with the keynote speech from genial Solicitor General Oliver Heald, subtitled "From Silting Harbours to Hot Tubbing: The Shifting Legal Landscape and the Imminent Effect on Solicitors and their Experts." It was a very interesting occasion because we're looking at a new direction. Hot tubbing, I'm actually quite convinced, is a good step forward myself. Whether that will be agreed by everybody, I don't know, but I can see the huge benefits there. Heald paid tribute to the work done by expert witnesses in civil cases, in criminal cases and in family cases, and the work of the EWI in supporting that work and maintaining standards. And he said, many of you may feel downhearted by these changes taking place, but I think that there are many reasons to be optimistic about the future of expert witnesses and the lawyers who instruct them. The independence and expertise of expert witnesses in the UK are great assets to this country. The English legal system and the lawyers that work in it have an international reputation for fairness and excellence. He said, we are a hub for international law and lawyers and for the settling of commercial disputes. And that's very much the way the government have seen what we're offering in terms of our the way we run the common law and the way we operate the courts, which is why it attracts a lot of overseas clientele. Now, at the beginning of the speech, Oliver had explained the historic background to the role of Solicitor General over the centuries, which was quite interesting, and he also recalled the history of expert witnesses as a long and distinguished one, so you could all get a nice pat on the back. Readers of the Barrister, of course, will be interested to hear that traditionally it's said that the first person to give evidence as an expert witness in legal proceedings in an English court was Charles Smeaton, who was a civil engineer and gave evidence in 1782 about the silting up of Wells Harbour in Norfolk, hence the silting issue. We will get on to the hot tubbing evidence in a minute. He would explain that the number and types of expert witnesses in criminal proceedings have increased. Accident investigations, very much in the news as I record this, facial mapping, and of course the increase in the use of DNA evidence. Quote, "Experts have a particular responsibility for making difficult issues and concepts understandable." Quite right too, they do. This is especially so in criminal cases where juries have to understand complex issues in cases in the Crown Court. Heald went on to say, "I know that there is to be a session on the expert witness and fraud." That was an interesting session. It's a complex issue which jurors for jurors and lawyers, and they have to understand if defendants are to have a fair trial. Expert witnesses making these issues understandable to lawyers, judges and juries play an important part in the administration of justice. And in fact, the afternoon session on fraud was very well attended and most informative. I certainly learned a bit. He'll continue saying that the quality of the expert witness can have a decisive effect on the trial. Their evidence can lead to the conviction or acquittal of the defendant. That's why the independence of the expert is important, and experts quite properly disagree, but their duty to the court means that their loyalty should not be in question. Looking at civil and family proceedings, he then turned to procedural matters, saying that the criminal procedure rules, the CPR and the FPR, are all clear. The duty to the court overrides the duty to the person that instructs you, and that must be right. The outcome of any judicial process should be the doing of justice. Expert evidence allows the court or the jury to reach decisions about things that are likely to be outside their area of expertise, and it's right that the expert's duty is first and foremost to the court. So these are basic things that perhaps some people are not quite so familiar with. This is why I put this in the article in the first place. He went on to say, in times of change, expert witnesses cannot be immune from this process, and the changes are affecting all participants in the justice system. Public funds are being reduced in the justice system in the same way as they have been in other areas of government, and the cost of proceedings more generally are under ever greater scrutiny. This is unavoidable. The challenge is to see how justice can continue to be done in this changing environment. You can appreciate there was relative silence with all of this being delivered. Heald then looked at fees. I wondered whether we were going to get some murmuring at this stage. We went into the issue of fees, which remained the issue of the day as far as I was concerned, saying that changes to legal aid expert witnesses' payments will have impacted those undertaking this important work. And I detected a buzz of strong interest at this point. He went on, first, a new set of fixed fees and hourly rates was introduced in late 2011 that codified for the first time the rates that could be paid to individual expert witness types. These codified rates were based on the benchmark rates that the then Legal Services Commission confirmed were routinely being paid to specified experts at that time, reduced by 10%, in line with the general reduction applied to all legal aid rates following the first legal aid reform consultation. Now, you appreciate this is a very controversial area. People were unhappy with it. The bar's been unhappy with these cuts as well as obviously solicitors have. He then went on to explain that the changes in how and when expert evidence is obtained and presented have actually occurred in the family, criminal and civil areas. He said that the movement was towards reaching agreement where possible, so that the issues for the judge or the jury to decide would be narrowed. And he said, quote, "There are likely to be cost savings in all of this, but it is also in the interests of justice, which must be everyone's consideration. It serves nobody's interests if litigation gets delayed by irrelevant issues. Obviously that's a straightforward fact which many people would certainly agree with, I would hope. In family proceedings, the government is working to make more appropriate use of experts and trying to raise quality and standards of expert reports. And one issue raised by the Family Justice Review was the fact that experts were sometimes unnecessarily and inappropriately instructed in family proceedings, leading to increased complications and delay. Clearly, he said, this could create uncertainty for families, especially children whose interests should be at the heart of family proceedings. He mentioned that the changes had been made to the family procedure rules being a precursor to some of the provisions of the Children and Families Bill, which at that time was currently before Parliament, aiming to make more appropriate use of experts to reduce delay in family proceedings. The bill, he said, reinforces the rules to ensure that expert evidence should be commissioned only where necessary to resolve the case. The court should seek material from an expert witness only when that information is not available and cannot properly be made available from parties already involved. Independent social workers should be employed only exceptionally. An interesting point there, and again it's a question of balance, I would have thought. Change is so often difficult, but these changes are fair, he said to silence. The requirement that the expert evidence must be necessary to assist the court to resolve the proceedings justly safeguards against miscarriages of justice. The test to adduce expert evidence appropriately secures the need in the circumstances of each case to balance the interests of the parents and those of the child, and meets the requirements of Article 6 of the European Convention on Human Rights. And he reiterated that it will continue to be for the judge to decide whether to give permission for expert evidence to be put before the court in line with the test. And in criminal proceedings, he said that CPR, the criminal procedure rules, and the overriding objective have led to the narrowing of issues and the focusing of expert evidence on relevant issues. And he then went on to the Jackson report and said that the government has sought to ensure that justice continues to be done, but that claims are proportionate and that the costs are not out of proportion to the issues involved. Whilst the report was specifically looking at the costs of litigation, as Sir Rupert pointed out, one of the principal complaints about expert witnesses was that many expert reports were too long and often addressed irrelevant issues. Well, you have to put up with that, frankly. I mean, that's he can say that, but at the end of the day, that's part and parcel of what we do, because we have to select the bits which are important. I think that's actually the role of the advocate, having put my little oar in with that point. Let's move on to the streamlining and hot tubbing. One significant measure which has been introduced and raised by Heald is the issue of concurrent expert evidence, piloted in Manchester from December 2010. It's called hot tubbing, frequently mentioned during comments. I found out what it meant eventually, because I didn't know. It envisages the judge getting all the experts together and asking questions of them about issues in dispute. Whilst the parties can also ask questions, in general, a full cross-examination or re-examination is neither necessary nor appropriate. This has been described as a major change, but, said Heald, there is no reason why such a procedure should not help the judge to decide which expert evidence to rely on. It's early stages, and the procedure is still perhaps most widely known by its slang name, coined I believe in Australia, of hot tubbing. Many expert witnesses are outstanding in their fields. I met them, and they were, and in demand all over the world, and legal services have made a major contribution to UK exports over recent years, and I'm glad he said that, because they do need a pat on the back. We do rely on experts, and they do an important role. Oliver concluded by saying, I hope I've made it clear that changes are also in the interests of justice. So far as expert evidence is concerned, we've tried to ensure that expert evidence addresses the important issues in the case and serves the interests of justice. Those expert witnesses in this room today, and those lawyers who instruct or call them to give evidence, play your full part in that process. So that was sort of the end of it all. There was significant applause. I mean, he wasn't booed or anything like that. And I believe his speech was greeted with a certain respect, although as the day progressed, the issue which emerged on everybody's mind was the fee levels, and the subject was dealt with in detail by Mark Stobbs, who, of course, many will know from his time at the Bar Council and Law Society. Stobbs was highly critical of the flat fee to be paid for either a plea or a trial, which takes no account of how much time and effort has been expended on the presentation and research for a particular case. And I have to say, when I went around a number of attendees with a straw poll, the Stobbs stance was very popular, and there were clear concerns about current government policy towards the provision of legal services. I can see why. I mean, it doesn't seem to be right to me, and I wonder whether other members of council feel the same way. But Heald was not present there to make friends, but more to explain what is currently being done with the deficit, and I believe he made a limited sale of his policies, which of course are hurting both experts and legal practitioners. Now having actually delivered this this little clip, of course it's now Sir Oliver Heald, and he has actually been removed as Solicitor General, and we have a new person who's literally just taken over with the summer reshuffle. So we've got a fairly substantial change with the removal of both the old Attorney General and the Solicitor General, and new people in their jobs. So we'll see what happens. Let me turn to Anthony Hooper, who was excellent. He was very pleasant gentleman. He gave me plenty of time. We had a nice discussion, and he gave an inaugural speech which I thought was fascinating about EWI. It was very well received. He's thought of extremely highly. It was a wide-ranging speech, and he set out 2 challenges for EWI from his experiences of some of the very many cases he heard whilst he was on the bench. Of course, he's a very experienced High Court judge. Expansion and accreditation, both of which I thought were absolutely spot on points, and it'd be interesting to see in 2014 what the EWI comes up with their conference then. With a flat 20% reduction in fees across the board, which they don't like, and the government's refusal to accept submissions from EWI, Hooper set out what he had in mind for the future. He said expansion of the EWI into new member areas would make the EWI grow, and his eye was firmly set on the forensic crime area. Quote, EWI has run some excellent courses, he said, and he put forward what turned out to be a not so new view on EWI assessing the work of experts on a day assessment. And I think that's probably a good idea, because accreditation, of course, is what it leads into. And I think we're in that sort of area now where you've got to have standards, you've got to have QA systems and everything else in place so that you know that you're getting the best you can get. After Sir Anthony, there was a panel discussion which was quite interesting, with Q&A sessions squeezed in, which gauged reaction to what was going on and the way forward for EWI. That was a positive and a very useful, slight change in the timetable, but very helpful. I think the attendees found that useful. There was a detailed series of breakout sessions, an excellent session from Suzanne Byrne. And let me give you the final word, because obviously I don't want to cover everything. I picked the stuff that was most important, because that's what we're probably going to be looking at for future conferences. But James Badenoch, Queen's Counsel, and I had quite an interesting chat. He's a retiring chairman, and he told me if criminal work is not done by highly competent, honourable and totally impartial people, then the fabric of society is in danger, and you will not attract those people who have these qualities whilst the fees paid are so grossly inadequate. Where are tomorrow's senior counsel and judges experienced in criminal work to come from? And he concluded by saying to me something we all recognised after that day at Church House: the pool of experts will be inadequate. Very much food for thought after a most interesting day with the experts, whom we often rely so much on. It was very good of them to invite me to attend. I've never been to one of their conferences before. I thought there were some very important points. I realised with the mere transitory nature of politics that things will change, but we've got an election in 2015. There could well be changes then, but at the moment there are some fairly substantial changes taking place, and I think things like the hot tubbing issue may well be very much models for the future, because at the end of the day we are entering actually quite a technical area in quite a lot of the evidence that's produced. So we are actually relying more and more on experts, and in experts in a wider range of areas. So the expert witness directory indicates the sort of range you've got. Anyway, I'd like to thank everybody who was so courteous to me during the day. It was a very interesting experience, and I'd like to thank the Barrister magazine, and this is the issue again if you've not seen it, for publishing my article. Very interesting, and I hope it's given you all some interest about what's happening at the moment. Thank you very much. Bye-bye.